Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast. And a big hello to everyone in between. As you can see on the screen, my name is Dan Balkaran, and I'm an employment lawyer at Samfiru Tumarkin, LLP, which as always is Canada's leading employee side employment law firm. So for the next 30 minutes or so, I'm going to be answering questions about all things employment law. Please send your questions in. I will try my very best to get to all the questions before the end of the session, but if you send them in early, there's a much better chance that I'm able to get to all of those questions. Okay, a couple pieces of housekeeping. I think we saw a little bit on the screen. If you need to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay, great. Let's make sure that the questions are getting posted. There they are. Okay, let's go through them. I'm not going to identify this person with their name because it's unique and would clearly identify who they are. So I'm just going to call this person Y. Y's question is, excuse me, my employer gave me the runaround on an accommodation request for my vision and ADHD. It's made it difficult to do my job, and I'm being forced to resign from a lack of support. What should I do? Well, I think that when you have a situation in your job that has legal implications, don't take any action. If you think that there's potentially some sort of avenue of legal redress, don't take any action that may make it harder for your eventual lawyer to assist you. So for example, resigning before getting legal advice may put you in a position of, we'll call it legal position deficit. It may be one that your potential lawyer may not be able to fully paper over, we'll say. So first thing I would do is before you resign, I would talk to a lawyer. Now, you've asked for an accommodation for your vision and ADHD, and your employer has, I don't know what giving you the runaround means. I assume that means that they're asking for medical confirmation and trying to find out exactly the limits of your accommodation, the accommodations you need, and just making it challenging as opposed to just complying with whatever it is your GP has said that you need. You could run into challenges if the nature of the accommodation that you're asking for runs to the core of what your job duties are. So for example, if you work in a factory and one of your core duties is to lift more than 60 pounds a day for most of the day, and you say you can only lift 20 pounds, you need accommodation for that. Your employer could say, well, find out if it's from your doctor, if this is a permanent accommodation. And if it is, could say that your employment has been frustrated by your injury and therefore you don't have a job and you're not entitled to any sort of compensation. So when you talk about medical issues, accommodations, your employer's willingness or lack of a willingness to comply with them, and then you throw in a potential resignation on top of it, these can be very complicated issues, and no one should try to navigate anything like that on their own. They should absolutely get legal advice. I will say for the second component of what you're saying, you're being forced to resign. The question is, do you have a human rights complaint? It depends on the nature of, I'll back up here a second. So your employer has a requirement to accommodate under human rights legislation, to accommodate your disability, if it is a disability, to the point of undue hardship. So you have to demonstrate that it is a disability and that your accommodations are not outside the core functions of your job, we'll say, like I was talking about earlier. And if it's an accommodation request that you do have a disability and the accommodation request is something that ought to be met by the employer, then you certainly have a human rights complaint. Now, human rights are handled differently in different jurisdictions. So in BC, for example, it's the exclusive jurisdiction of the BC Human Rights Tribunal, which is having some challenges in terms of efficiency. And so I believe the tribunal said it takes about 4 years for a matter to get from complaint to adjudication. Now, 4 years is a very long time. Things change dramatically in 4 years, and waiting 4 years for redress, particularly if you stay with your employer but you submit a human rights complaint to the tribunal while continuing to work there, that's a long time to have a solution now, or some sort of resolution. But in your case, you said you may be forced to resign, and so a different angle to pursue as well. If you are forced to resign, and I don't recommend that you do that until you get legal advice, but to what extent has your employer effectively, constructively terminated your employment by failing to provide reasonable accommodations to you that you require to function in the workplace at a reasonable level? And so I don't know very much about that. It sounds like a repudiation argument to an extent for failing to provide accommodations, but certainly there might be something worth investigating there. I personally have never encountered a fact pattern quite like that, but certainly I would talk to a lawyer first before you resign to find out if there's, first of all, if there's any utility to that particular argument, and second of all, if there's any value. So if you've been working there for 6 months, probably not very much money coming to you. But if you've been working there for 25 years and you have no employment contract, then it certainly may be worth kicking the tires on a constructive dismissal, which 25-year employee, depending on your age and your contract situation, could be very lucrative. It could be as much as 24 months of pay. So certainly before you do anything, you should talk to an employment lawyer. Okay. Question from LJ. Can a company ask an employee to interview for a different team during or after maternity leave? So your employer has to provide you with your old job back after your maternity leave, or a job that is substantially similar and similar pay and all that. If it's going to move you out of your role, it needs to have a fairly good reason, like a reorganization or acquisition or something changed the nature of your position. If they just gave your position to somebody else and then didn't give it back to you, they incur human rights liability, which we talked about, or I just talked about with the last question. They incurred human rights liability on the basis of sex, but human rights damages tend to be on the smaller side, and certainly if you combine it with lost wages / severance, it can be quite a bit more. But if you do bring a human rights complaint like that, I can't see your employment at that company lasting too long. I mean, they can't commit reprisal against you, but nonetheless, when legal proceedings are initiated against an employer, pretty hard to maintain your employment after that. So what's missing from your question, though, is can a company ask an employee to interview for a different role or team during or after maternity leave? Well, what if you don't? Do you lose your job? That's the part I don't understand, and that's the real meat of your question, because they have to put you back in the role you had before, something substantially similar, and if that's just not open, what are they going to do? Are they going to let you go if you don't interview for this position? Certainly, you'd have a discrimination complaint, but again, depending on your jurisdiction, that could be a very slow avenue of redress. Again, in BC, 4+ years, 4 to 5 years to get a human rights complaint to go from complaint to adjudication. So, you also have to ask yourself if this is a company you want to continue to work at, or would you prefer to try to get some money on the way out the door, given the way they've treated you during the maternity leave. But if this is somewhere you've been at for 10 years and you could be at till your retirement, then maybe being placed in a different role is fine with you. These are all questions you have to ask. Certainly, I would encourage you to talk to an employment lawyer to assess your situation. I don't know if you're still on maternity leave. There's just a lot of unanswered questions in your question. But can they ask you to interview for a different role? Well, I mean, again, they're supposed to put you back in the role that you had or something substantially similar. And if they don't have your role, they should place you in something substantially similar, not say, hey, interview for a role that we have over here because your old role is not there. Well, what happens if you don't get the new role? Are you without a job? So there's a lot of unanswered components or unstated components to your question, but certainly you're going to want to talk to an employment lawyer. If you want to get a hold of us, you can do so at employmentlawyer.ca, help@employmentlawyer.ca, and 1-855-821-5900. Okay. I hope that answers your question. LJ, if you have more, please let me know. Sue asks, my sister was let go from her probation period from her management position. Her supervisors and coworkers made a lot of misogynistic comments and often brought up her sex as being a problem. She recorded a number of these conversations as well. Would she have any grounds to go after them, or are they safe because she was still in her probation period? This is a very good question. Okay, so I don't know from your question, Sue, if she was in a non-managerial role and then was promoted to a managerial role and had a probation period within the managerial role. If that's the case, she's not really on probation. She may be on probation for the role, but I don't personally believe that I actually haven't looked at the law on this, but I don't think the core notion of probation, which is that an employee can be let go without notice and without pay during the probationary period. I don't, if they're not suitable for the position, I just don't think that holds any water. And so whatever if she was promoted and she's a longstanding employee, for example, whatever severance entitlements she would have had based on her contract length of service and position, she would still have it. But the second part of your question, if she has recordings, so I'll back up here a second. This seems to be Human Rights Day. So there are certain protected grounds that an employer can't discriminate against you on, or in this case, against your sister on. And if the employer does, then you have the ability to pursue a remedy through the human rights regime, whatever the regime is in your particular province or in the federal jurisdiction. And so when I say remedy, I mean damages in a couple of different flavors. So money. So you have the ability to pursue money for the discrimination on the basis of the infringement of the protected ground. And while that sounds complicated, inherently you can't discriminate against, and it varies slightly by different jurisdiction, but they're broadly similar. You can't discriminate on the basis of age, race, ethnicity, sex, sexual orientation, gender identity, ancestry, criminal record, disability. There's more. And so for you, the fact that your sister was a woman and getting discriminated, and I didn't quite follow it, that number of conversations recorded of misogynistic comments made up about her because she was a female manager. If that's what I understand your point is underlying your question. If she's got recordings that actually show misogyny in terms of the management around her, in terms of their comments, and I think it's plausible to connect the dots between that and being let go. And so the actual termination itself would be discrimination on the basis of the fact that your sister is female. And I think she would have a human rights complaint. And the fact that she's on probation or not doesn't matter. The only thing that, at least not in BC, and I don't imagine it matters anywhere else, any other human rights jurisdiction, the fact probation doesn't matter. All that matters is that there was discrimination. If there was discrimination, you have an entitlement to damage on the basis of a protected ground, in this case, that your sister is female, so on the basis of sex, she'd be entitled to human rights compensation. So I would certainly talk to an employment lawyer because of those two items. So again, the first one being, was she a brand new manager and a brand new employee, or was she an existing employee who was promoted? If the second one, certainly you want to talk to an employment lawyer right away. And then for the second component that I said, if she's got the goods on the recording, if there's a recording that shows misogynistic commentary from leadership employees, then I think she's got something. Especially if the timeline is, misogynistic comments, termination shortly afterwards. Now, if it's from peers and not leadership employees, then you'd have to tie it to, in order, I think, to establish human rights liability, you have to tie the termination to discrimination. So if she was terminated for a different reason other than the fact that she's female, then she wouldn't have an entitlement to human rights compensation. But the tie doesn't, it doesn't have to be ironclad. It's not a high standard of proof. The temporal connection, like here are the comments shortly after fired, generally probably enough to get you moving in that direction. So I would talk to an employment lawyer, and I'd play those recordings for the employment lawyer and see if you've got something. And I'll give you all the information for us later on. So I'm just trying to read these second questions, and I'm having a challenge with it. I think this is someone or male. My lawyer itself is forcing me to resign. I don't know what that means. And then my IME says I can go back to work. Okay, so you have a medical situation. Your employer asked you to go to an IME. The IME says you can go back to work. You don't want to go back to work. I need more information. Please provide me with your specific question. Okay, Martin asks, is a severance offer allowed to stipulate? Hold on a second. Is a severance offer allowed to stipulate that refusing a new position means your previous employer can decrease or stop paying severance? Okay, so this leads into a much broader answer that I need to load some background into. So if you're provincially regulated, and 90 to 95% of employees are, you are going to have some ground floor mandatory entitlements in terms of notice or pay in lieu of notice. If your termination is today, it's pay in lieu of notice, which I'll call severance, which is money without having to work for that money. The ground floor entitlements that are mandatory come from the Employment Standards Act. Roughly the same in every province, close to 1 week per year of service to a maximum of 8 weeks. Some variation on that per jurisdiction, but roughly that. So you get those automatically, and those can't be diminished in any way. Up to 8 weeks, depending on per year of service that you've had there. If you've been there for 2 years, probably entitled to 2 weeks of severance. Okay. However, if you have no contract that legally limits you to those statutory minimums, you're entitled to, we'll call it big severance. Now, big severance is it's really an assessment by courts based on other decisions by courts over time about how much big severance should be, and it's roughly 1 month per year of service, but adjusted for your age, length of service, position, availability of similar employment. So older you are, more severance. Older you are, about 50, more severance. More years of service, the more severance. More senior the position, more severance, because those positions are deemed to be harder to replace. And then if you have a disability or that would make it harder for you to get a new job, or you're in a hyper niche industry, or there's a downturn in your industry, you may get more money for there being a lack of work. But conversely, if you're a legal assistant, for example, and there are hundreds of jobs available in most jurisdictions all the time, you'll get less severance because it's deemed by the courts across time that's easier to replace those positions. Okay, so your employer cannot give you less than the statutory employment standards minimums, but they're small, right? if the employer chooses to make you an offer over and above those minimums, that is an offer that they don't mandatorily have to provide you. Okay, now they're doing that probably because they don't want you to hire a lawyer, or they looked at their legal position and they owe you this much money, and so they're going to offer you this much and see if they can settle it fairly easily. Now, what you're talking about is that the offer comes with, it's probably a working notice offer, which says, or not working notice, sorry, salary continuance offer, where we're going to pay you for 12 months or whatever the number is. However, if you get a job somewhere in those 12 months, you have to tell us, and we will pay you 50% of the remaining amount as a lump sum. So you get a job after 6 months, we'll pay you out 3 months. So they save money, you save money. Now, the question is, and sorry, you get less money than the entire 12 months, but you have a new job. And so the question that you're asking is, can they do that? And the answer is yes. They don't have to offer you anything. Of course, if they don't offer you anything, and the offer can have different stipulations in it that change the nature of the offer depending on certain milestones, or triggers being met. It can be time limited. So, we're going to offer you this amount for 1 week, and then the offer is revoked, for example. But if they don't offer you something that is, we'll call it fair within the four corners of what the law is and what you're legally entitled to, then they run the risk of you hiring a lawyer like me to pursue your full legal severance entitlement. And then the employer will have to not only reckon with what you are entitled to legally, but also the legal fees it has to pay its lawyer to defend your claim. So it's a double hit for the employer. And so in that balance and financial gray area and uncertainty, deals get done, we'll say, and settlements happen. And so for you, yes, of course they can put in something that reduces the amount if you get a new job. The question for you is, do you want to take that? And I would recommend, before you come up with an answer, that you speak to an employment lawyer and find an employment lawyer assesses the value of your claim at. And again, if you want to get a hold of us, you can do so. employmentlawyer.ca, helpemploymentlawyer.ca, 1-855-821-5900. Okay. Renee says, my coworker has been working for a delivery company for 5 years on a route that requires no heavy lifting. Now the company wants to change this route to one that requires a lot of heavy lifting. He's 60 years old and can't handle the heavy lifting. Is this grounds for constructive dismissal? No, because they weren't aware they're not aware yet of the change. So what I would do is, or let me rephrase that. An option that is open to your friend to pursue is to get a doctor's note saying that he cannot, that the employer must refrain from giving him duties that require him to lift more than X amount of pounds. Okay, and now the challenge with that, and I don't know what the core duties of your friend are, but if a core duty is lifting heavy objects, then this could be a problem. And if the employer can demonstrate that, he could potentially lose his job and have no entitlements. But he may also want to continue to work there. There's certainly a lot of delivery driver jobs out there. So, it may be that the employer wants to keep him. Some sort of balance of a medical note and an amicable conversation saying, listen, I can't, can we just keep me on my route? I can't do this due to my age, etc. Can we find out some sort of working compromise? That might go a long way, right? But if they say no, you'd certainly have a human rights complaint. I think you would probably have a constructive dismissal if you have no choice but to not be able to resign. But I don't know if I would resign. I would just, I would work in whatever route they assign to me, and then I would just not do the heavy lifting part and see what they do. That's probably what I would do, but I'd have to give that a little bit more thought. But I would, probably an amicable solution is the best one. You don't know what the employer is going to do. They might not be aware of the lifting limitation. This might not be sinister at all. Doctor's note plus frank discussion, reasonable discussion may in fact may in fact solve the problem for your friend. However, if your friend is trying to get out with money now, then certainly there are steps you can take to try to get to a constructive dismissal. I'll just say 5-year employee delivery company. So a lot of driver jobs out there. Certainly a discount is going to have to be taken. You're not talking about a windfall by any stretch of the imagination, even in the best case scenario. And constructive dismissals are difficult, particularly in the situation you're talking about. So more of a discount would apply. I think that before your friend tries anything and just in general for everybody, do not try initiating a constructive dismissal on your own. They're very complicated. They're very hard. If you get it wrong, you get 0 and you quit. Okay. So always, if you want to pursue a constructive dismissal, do so with the benefit of legal advice. Get legal advice first. Okay. Angelo asks, my employer called me back and told me not to come back. I call you back from what? Not to come back. They offered me 3 weeks of severance. Is that enough after working there for 3.5 years? Well, what they offered you was the employment standards minimums. So whether or not that's enough depends on what your employment contract says. If your employment contract does not limit you to the Employment Standards Act minimums, then it's not enough. However, if it does, then that's just the actual minimums. I don't know what they called you back from, though. Are you on a layoff? So certainly, Angelo, you're going to want to get legal advice to take a look at that contract of yours if you have one. If you don't have one, then certainly it's not enough money. And I'll give you the information for us at the end. Robin says, I'm not going to list out the name of your employer. They have been very difficult with accommodating a medical leave and are now asking me to accept the layoff or resign instead of returning from my leave. What rules do... Oh, I'm sorry. You said it's a not-for-profit. Okay. She works for a not-for-profit. They're asking her to resign or accept the layoff. No. What rules do not-for-profits have when issuing layoffs? They're the same. They're absolutely the same as any. You're an employee of a not-for-profit. It doesn't matter what their business structure is. The rules don't change. You're there for 6 years, and you find it ironic that we are supposed to support vulnerable people, but not the staff. Yeah, I mean, oddly enough, I've found that not-for-profits often are quite aggressive with their employees. I mean, that's maybe not always the case, but I've certainly seen it more than once. Medical cases are hard, right? So again, your employer has to accommodate you to the point of undue hardship. If they fail to do so, you have human rights damages coming to you, but those tend to be small and perhaps will take a long time. However, if your employer refuses to let you come back because of your medical issue or just says, no, there's no job here for you, like if they put it in writing saying resign or go on a layoff, we don't want you here, I think you have grounds for claiming a termination already, but that can be a little tricky. You don't want to get that wrong. So certainly you're going to want to talk to an employment lawyer to tailor how this is done, because it sounds like you probably don't want to be there anymore based on what is happening. But again, accommodation requests and getting out and whether there's value to getting out, i.e. what does your contract say, that can be challenging. And so I wouldn't take any action if I were you until you have the benefit of legal advice, specific tailored legal advice that can assist you and guide you with either how you exit or how you deal with the fact that they're not willing to provide you with the accommodation. Because medical, I mean, I think there were 3 or 4 questions today about medical accommodations. They can be very, very tricky. You don't want to get into a battle over what do the medicals say. And oftentimes employers want to do that. They want to get into the nitty gritty of the detail to show that your limitation is central to the nature of the position, and therefore it would be an undue hardship for them to have the employer to have to accommodate you. But again, if it's fairly reasonable what you're asking for, and they're just saying don't come back, you could take that opportunity to treat it as a constructive dismissal of your employment, and then you could pursue severance remedies, which you've been there for 6 years, aren't, I don't know what you were making, but probably isn't going to be a massive windfall, but nonetheless probably allow you to get out with some money if that's what you want to do, considering the way that the not-for-profit is treating you. Okay, we just got through the last question. Very good questions today. Thank you for sending them all in. If you need to, and I said to a number of you that you should get specific tailored legal advice. If you need to get a hold of us, you can do so at employmentlawyer.ca, as you see on the screen, help@employmentlawyer.ca, and 1-855-821-5900. Okay, that's it. Thank you very much for your great questions. I'll be back here in 2 weeks. Join us on Monday. I don't know if that was on the screen already or not, but join us on, I believe, Monday for our next live question and answer session. I will be back in my usual time slot in 2 weeks. So other than that, have a wonderful and safe weekend.